So I just want to welcome everyone back, and I think the importance of this topic has kept people um, to continue to engage in this webinar. And I just want to thank you for being here, and to thank SRDC to pulling this together, and for the team of Robert Zabawa, Zara Woods, and Connor to keep at it, and their creativity, and for Lorette Pachano from the Rural Coalition for her work, leading the work in the 2018 Farm Bill. So my name is Savvy Morin, and I'm with the Land Loss Prevention Project. And we were founded by the North Carolina Association of Black Lawyers 37 years ago, looking at the same problems that we're dealing with today with heirs property and discrimination by the U.S. Department of Agriculture. Some shifts and improvements with, of course, USDA, but the issue of heirs property continues to tug at the heart of what we need to do. We did get some progressive legislation, model legislation coming from the Uniform Law Commission, largely due to the efforts of Thomas Mitchell and the other commissioners. And so now we have a real tool that we hope will turn the tide on heirs property. So welcome back. And I know that we have done a lot thus far on heirs property, so I might somewhat go through the slides a little bit. But before I go, I would be remiss in not giving Tuskegee its kudos and Robert Zabawa and Tom and others for the study and the body of work that it has done on heirs property in Alabama, which has led the way and developed a scholarship around heirs property. I'd also like to give kudos to the historic work of the Federation of Southern Cooperatives, but prior to that, the Emergency Land Fund that began to put together tools to stem Black land loss, and many others, and the later period of organization. But those are the backbone of where we stand on this work. So let me go to the slides. Next slide, Robert. So this is maybe a little bit irritating. I mean, you have heard some of this throughout, and it had to do with of course, the long history of racial discrimination, Jim Crow discrimination throughout the South, and the lack of access to legal assistance, which is still problematic. I think Connor brought that out very skillfully when you look at the map of the South. And then look at the ways in which state law determines what happens, largely on the issue of heirs property, and just how differential the family could be with regard to the land, the legacy, and economic pressures. And also, at times the pressure is so overwhelming because of the loss of wealth within African-American families, that people look at the last thing that they still own collectively and decide, well, we need to live, and the land needs to be productive, and one way in which we can do it is to get our share so we can move on with our lives. So there are many angles to all this, but at the end of the day, once land is lost, it is lost. Next slide, please. I believe in terms of the latest numbers, this is somewhat off, but clearly by 1997, you had fewer than 2 million acres of African American farmland that was owned. Of course, we've seen the figures of close to 16 million by 1910 in the slide that Dr. Woods showed, and now 1997 to be down to 2 million. And there are historical underliers for all of this, of course, the Great Depression, all the different recessions, and the effect of Jim Crow era on that, the inflated tax assessment and the high rate of tax foreclosure that was skillfully brought out earlier, and just how discriminatory lending practices are and how disproportionately it impacts African American landowners and homeowners, and also the lack of attorneys. And I must say, across the board in rural America, whether you're down south or upstate New York, there is that need for lawyers to manage estates and transfer of farmland, and there's just not enough lawyers. And we need to fix that problem and develop creative ways to bring back lawyers into rural communities. Next slide, please. So I think it's really important to kind of get a grounding of Pigford versus Glickman and what it meant on the spectrum of Black land laws. So the Pigford case essentially was the largest discrimination settlement in the history of the United States, with the main actor being the U.S. Department of Agriculture, the government itself. And so while there were close to $1.2 billion in settlements, and that there were 2 periods of the settlement negotiation, so it was about $2 billion, you still had a loss of wealth of close to $120 billion within the period of 1920 to 2012. Within the Black farm economy and Black landowners. I think the key piece that I'd like you to take away from the Pigford is that when you look back in time, and I just, it's not on a slide, but for want of trying to give my other partner the time to get on the call, I just want to bring up some numbers, just so you understand. So the largest decrease in North Carolina, where I'm calling from and where I do my work, happened during the Civil Rights period. And that was at 1954 to 1969. And what we saw was in 1954, I'll call it 23,000 Black farmers were farming the land. And that by 1969, that figure was down to 9,600. And then land went from 1.1 million in 54 down to call it 600,000 in 69. So when you kind of put those numbers together, you can understand the magnitude of land loss that was caused by the USDA and by heirs property, and as some would call it in our current period, land grabbing of African American land resources. So, next slide, I could keep going on and on, but trying to exercise some discipline here. So what put a lot of heirs property at risk is the role of property taxes and the burdens of heirs property owners to coordinate paying taxes. And we heard it eloquently from the Vice on the loss of the land and the interview with the elder in Washington, D.C. on that piece, and the rendition of what happened in Lisbon, Louisiana. Black folk, as difficult as it was to navigate family relationships, people tend to pay the taxes, and it was like religion, because they knew once you stop paying taxes, you're going to lose the land. And that was often the case. And that when you are about to have tax foreclosure, developers or other people interested in getting at the property can easily find the record of pending foreclosure, sale, and taxes, and show up on the date of sale and bid it up, bid it down, depending if there are competitions. So we did lose land due to tax foreclosure that played a very significant role, as well as heirs property, as well as discrimination. Next slide, please. So over the years, there's been a number of strategies that came about under state law. Everything is driven, because it's property, by state law. And to use some of the legal tools, if you had a lawyer that you could use, or even doing some front-end work within the family to get at protection of heirs property. One of them was to develop an heirs property owners trust, in which members, heirs deed into a trust their interests. And the benefit of that is that the property will be held for the benefit of all of those who deed into the trust, and that by appointing a trustee to manage the trust, that trustee can control the land and is responsible for maintenance and the taxes, and also to it would give the trustee entree point to access the USDA and get into programs, because you now have a titling piece to the land, which if you didn't have, you wouldn't be able to access resources by the USDA. Some people use that to get into commodity programs, depending on where you are, like places like Arkansas and Mississippi, getting into rice production and cotton. Next slide, please. So it all starts with all three, Robert, Connor, and Kara went through, and we did an exercise as well about the importance of identify heirs property owners. And of course, it always starts with recreating or creating, in most instances, is the first time, the family tree, talking to the elders, getting dates of death, marriage, and divorce, because all those individuals play an ownership interest in the heirs property. So by getting your family tree as complete as possible will help you to look at who owns what and the percentage. You can also go to the Register of Deeds, which keep all the land titles in your county, and as well as search the clerk of court records to find any kind of judgment or estate files regarding the land. And a key piece of this that a lot of people don't quite recall is that we know about the tax foreclosure, but one must also know that judgment creditors, people who have a judgment on any one member in your family, could force a partition action. So that's just how vulnerable this estate and land is to so many factors, that it really behooves everyone to get together and figure out how they're going to manage the land, but for the future generation, and that the millennials need to sit on top of the baby boom generation and get them to do will, because it's that important for orderly succession without over engagement of state processes in their lives moving forward. Next slide, please. So one of the legal instruments that can be used to protect land that is heirs property and to maintain it is to form what is called a limited liability corporation, in which you create a business entity and transfer your ownership rights in the property into the LLC. Because it now becomes a legal business structure, that now becomes an entree point to get in into USDA and getting moved in with conservation services. And I think that's really important because it really is an excellent structure to really manage the land and to develop it to meet the needs of family members, as well as critical decisions about maybe the land remaining in agriculture or which portion of it could be used for agriculture. Just doing a multi-use analysis, looking at what is needed by families. So I think that's really critical. It's a democratic structure. You share profit, you share loss. Next slide, please. Another strategy is a tenancy in common agreement, in which all the heirs get together and they set out what the rights and responsibility of the heirs property owners to each other. It sort of is like a hybrid between a trust and an LLC, and it really is an excellent way to manage heirs property. And anecdotally, we saw how tenants in common agreement was used in New Orleans after Katrina. That was one of the vehicles that was used to help people to access federal programs such as the Road Home, because in studies on New Orleans, a lot of the homes in the lower Ninth Ward and spreading across the city were heirs property, because everybody knew it was grandma's house and it was a family house and people lived in there and raised children in there. And that was lost after Katrina. And so tenancy in common agreement figured largely in replanting African Americans in New Orleans, but not nearly as enough as we know now. Next slide, please. So one of the strategies, and I'm a big proponent of this, is to use a community land trust model in which there is, it's a nonprofit corporation, and you can gift land into it, or you can purchase land and put it into the community land trust. It's a democratic structure because you can determine how much land is used for housing and for business or just agriculture. We believe that community land trust is a very viable legal structure to save Black-owned land. One of the oldest community land trusts was African American and was founded in Southwest Georgia, and that was called the New Communities. They lost most of their land, and it took the Pigford settlement to get them enough resources to purchase a 1,600-acre plantation and repurpose it as resort. The original community land trust, New Communities, had about 5,000 acres of land. Next slide, please. So, I mean, as I mentioned, and I jumped ahead of my slide in the moment, the New Communities Land Trust was the first to be organized and be incorporated in under state law, but you also had forerunners to this. Fannie Lou Hamer's Freedom Farms were also agricultural cooperatives and those were founded during near the tail end of the civil rights movement to stabilize Black land ownership, as well as to give Black people a place to live, because many were chased off former plantation land as they decided that Black folk engagement in claiming their civil rights struggle earned them the right to be kicked off their land. And so Fannie Lou Hamer Freedom Farms was able to house Black folk, and the farms were able to feed the community. So that was a very important forerunner. Today, there are some current initiatives that's being led by millennials up and down the Atlantic and in the South around communal land structures are collective. We see Black dirt in the Eastern Shore of Maryland. We see Ferry Farms in Surrey, Virginia, using a hybrid model of ownership. We see Leah Penniman and the farm, as well as Soulfire, which is founded by her farm family, but the expansion of that into the Northeast People of Color Community Land Trust. We see the emergence, of course, of the Black Family Land Trust, and all of these were built on a solid history of Black folk looking at alternatives and strengthening models that had been tested. So we see it continuing to this day. In North Carolina, we have Earthseed land development, which includes a farming infrastructure and housing. So we're seeing more hybrid models being used to meet the needs of emergent agrarianness, whether they be in urban centers or rural areas, their need for land and structure. So I see this as a very creative moment in experiencing all these various structures by young people. Next slide, please. We are also seeing the use of historic preservation to look at preserving and protecting historic African-American towns and infrastructure. We have an African-American Cultural Heritage Fund. We also have a Gullah Geechee corridor that is protecting those heritage. And we're also seeing historical preservation being used in manner that is slowing down the gentrification process. And I would call this rapid racial gentrification of historic Black communities. Next slide, please. Uniform Partition of Heirs Property Act. I'll be sharing information from the Uniform Law Commission, which developed the UPHPA. These commissioners got together and develop a model piece of legislation for states to adopt, and that I believe could play a beneficial role in stemming Black land loss in places where it has been adopted. Next slide, please. And so this Uniform Law Commission was established in the 1890s to draft uniform state statute. And as you see that it's quite a body of people sitting as part of the process. Thomas Mitchell was a commissioner in developing the Uniform Partition of Heirs Property Statute, and he has been noted for his scholarship and the development by the MacArthur Foundation, as Robert mentioned earlier. Next slide, please. So their drafting process, one would say, is laborious. It takes about 2 years from start to finish. The American Bar Association can appoint advisors to the drafting committee, and they come from all walks of legal profession and are recognized as experts in their field, and commissioners tend to have a very sound grounding in public policy and what is needed. Next slide, please. So the Uniform Partition of Heirs Property Act grew out of studies with the American Bar Association led by Professor Thomas Mitchell, and then with the Uniform Law Commission as a follow-up. Our organization, the Land Loss Prevention Project, reviewed, made comments in the review process for the UPHPA, and it has so far been adopted in 17 states. Virginia was, I think, was the last one after New York to have adopted the UPHA. But the interesting thing is New York and Virginia tweak the Uniform Partition of Heirs Property Act to encompass urban dwellings. So it's not just rural farms, but it now encompasses urban dwelling. I think had that been part of the process, perhaps we could have saved some homes that became subject of rapid racial gentrification. So it's better to have it now than not to have it, but I'm glad those 2 states took a different view and expand the reach of the law. So for additional information, please go to the website. Here, ULC's website on the Uniform Partition of Heirs Property Act. Next slide, please. So these are the states in blue. This is not complete because there are now 17 states. Mississippi has adopted the uniform law. Thank you, Robert. And I have to give kudos to Montana. It was the first to adopt it for very good public policy reason. As most of you know, the expanse of land there and the several thousand acres of ranches that families own, their public policy was to control development and break up of these very large estates of land to keep the rural and the state symbol of, rolling, beautiful and open farms. So Georgia did adopt, as you can see, and South Carolina adopted right after, I wouldn't say right after, but it was part of the impetus for adopting the Uniform Heirs Property Act was the murder of Reverend Pinckney, and the statue was named after him, and the governor signed it into, made it state law in his honor. So there, as I said, New York was also added recently, and Connecticut has been there for a while. Texas in the deep south is also a signer. So most of the ones that have been introduced in 2019 have been adopted. Next slide, please. So for the most current list and current map, please go to the ULC website. We've been through this slide, and just in broad strokes, as you know, it's heirs property is intestate, people dying without leaving a will, and the many heirs and tenants in common with access to the land and the legal infrastructure that can get at it, state law, and that these properties are at high risk in places that are slated for development, and in some instances for natural resources, as we saw with the clearing of the land and the timber, and in places where there is gentrification pressure. Next slide, please. We've been at this, but I'm just, there is a Q&A, a question that we can come back to, so thank you, Michael, for that. So the problems with heirs property we have dealt with, and again, you know, it's unsecure. It can become quickly fractionated over time as family grow and multiply, and that it's very difficult to get 100% agreement on what should happen with the land. I believe under the Uniform Partition of Heirs Property Act, you're looking like 50% of the heirs can make a determination, and that the no clear title hampers the ability of heirs property producers. So if there are farmers on the land, to access USDA program. Next slide, please. So this is some of the benefits of the UPHPA. It enhances oftentimes notice. The notice provision is enhanced so that, as you recall, in the Lisbon, Louisiana case, the point of, you know, we have a local newspaper. It's not like it's delivered at people's doorstep. It's not the New York Times. It's not often read. And so the UPHPA, with the enhanced noticing requirement, it goes beyond just mere publication, but posting of notices on property so that the community would get information that a particular property is a subject of a partition action. You get independent appraisal for the value, which is critical, because if you don't have independent appraisal, then it could be lowballed. And when the division amongst the heirs occur, it just could be very, very low, as demonstrated in the films that you have seen. There is in the UPHA, the market-driven process of partition by sale is not preferred at all, but it encourages partition of in kind, which is the division of the property. But what it does, it provides a cooling off period for members in the family to pool their resources together and purchase the land as a collective. Would position it in other legal instruments like a trust or a CLT. Next slide, please. So I mentioned this in my broad out, strokes, that you have now enhanced notices to the heirs, and there is a provision to really locate heirs so that people can have notice of the action and can appear in court. Okay, next slide, please. The independent appraisal under the UPHA is a key process in getting to a fair price for the land, especially when it moves to a partition sale. Next slide, please. So under the uniform law, co-tenants who did not request the partition sale may purchase the shares of the co-tenant, which is why, of the other co-tenants, which is why you have a cooling off period to get people to come together and pool their resources to purchase the property. Next slide. As noted previously, I reported that the partition in kind is preferred and not the market-driven partition sales using a market price to determine, and usually that is so deflated that all the heirs will lose the economic interest and benefit of having held on to the land for such a long time. Robert, I'm losing my voice. But I'll keep it going. Need some water. So there's heightened requirements in the open market sale. Essentially, to summarize it, that there be no insider trading in which lawyers and court personnel and commissioner of sales can order and tie up the sale of the land in their interest. It moves towards more transparency in the sale process, and get to a place where you know, you can get a sealed bid or an open auction, and that the court, of course, has the right to waive the open market sale if the other method is a much better process.